Yes, Mr. Malik.
So I was at JN Cameroon. I had shown you what submission was in that case at paragraph 18 at page 240.
Yes.
Now, if you look at page 241, you'll see at paragraph 21 a reference to the Immigration Directorate's instructions, and you'll see that the word must is used. That too made it clear that the destination must be specified and the notice must be signed. The court took the view that, well, shall and must has the same effect. They both were mandatory. The analysis starts at paragraph 21, and the conclusion is in the second sentence of paragraph 21, that the non-compliance with the mandatory requirement in the regulations does not give rise to invalidity or deprive the tribunal of jurisdiction to entertain the appeal. There then are reasons for that conclusion. The reasons that are, in my respectful submission, relevant to the argument that I'm seeking to pursue are at paragraph 27. The first point that is made at paragraph 27 is that the proposed destination was clear and that the appellant's ability to present his appeal was not impaired in any way by the failure to state the destination in the notice. So this is what the court has in mind there, in my respectful submission, is the position at the appeal hearing. So at the appeal hearing, there was no doubt that the proposed destination was Cameroon, and there was no effect on the appellant's ability to present the appeal.
I think they're saying the proposed destination was clear at the time the relevant notice was given.
No, the submission that I'm making, Lord, is that what is being said at paragraph 27 is what the position was at the appeal hearing, to present his appeal to the tribunal. And if you read the next paragraph, Lord, you'll see that the position would become clearer.
I see.
So next paragraph, if, which is not the present case, the proposed destination was unclear and were not clarified in the course of the appeal process, even then I do not think that would result in invalidity of the notice of decision. So this applies here, in my respectful submission, by analogy. If the position was clear at the date of the appeal hearing, that the worker had no leave to remain.
Well, if it only becomes clear at the date of the appeal hearing, then you've not actually given him time to prepare his appeal. He needs to know before he prepares his appeal what the situation is.
Yes. So in this case, the position was clarified sort of well before the appeal hearing. So this is when I gave you two dates. So on 21st of July, Secretary of State serves evidence showing that the worker had no right, has no leave to remain.
But you're entitled to have 28 days of knowing what the case is, to decide what to do, decide whether to take the discount, and decide whether you are going to object. It's all too late by the time you come to the appeal hearing. That opportunity has been denied you.
That particular opportunity to pay the reduced fee, yes.
And the opportunity to decide, make an informed decision about whether to object or not to object, whether to appeal or not to appeal.
Yes.
It's no good to say that by the time you get to the appeal you know, because by that stage it ceased to be relevant. But the whole point was whether you ever get to as far as an appeal.
So at the appeal hearing, the judge decides whether the CPN is invalid because there was a non-compliance with Section 15(6). In deciding whether the non-compliance resulted in invalidity, in my submission, the court must consider whether the position as to the liability is clear or is not clear, or whether there is or there isn't an impairment in the ability of the appellant to present the appeal to the judge. In this case, there was no such impairment. This is because the appellant ultimately accepted the evidence that the Secretary of State had adduced before the appeal hearing, that the worker had no right to remain. And therefore, the appellant was liable to imposition of penalty under Section 15(1). The alternative point is made at paragraph 28, that even if things had not clarified in the appeal process, that would effectively be a point about there being no effective opportunity to present his case, rather than resulting in invalidity of the decision.
Right. I mean, that is specifically looking on to later processes where, in effect, the individual's rights would be protected by other procedures.
Well, true, of course, but I say with respect that we are within paragraph 27.
Right. Well, I mean, just for what it's worth on that, has Penny not had any material adverse effect on fulfilment of the purpose for which the requirement is imposed? I'd say, reading that for myself, I think that is referring to the fact that really from the outset it was known that the destination for deportation was going to be Cameroon. So he knew that if he wanted to appeal, that was the target that he had to aim at to show that it was wrong. That's why the requirement had failure to comply with the requirement had not had any material adverse effect on fulfilment of the purpose, because he knew completely right from the beginning and knew what he had to do if he wanted to appeal.
Lord, and that is the reason why I especially showed you paragraph 28, that if you read, not making a point about paragraph 28 other than to say that if you read the two paragraphs together, in my submission it would appear that the court was making a more nuanced point, which was that...
With respect, I'm not sure that's right. 28, I think the court is deliberately looking at a far worse situation. So 27, it seems to me, is looking at the position when the notice is given, and I think there was a covering letter, wasn't there, which made it clear, all at the same time. 28 is then addressing a hypothetical case if things had been done much worse, if there hadn't been clarification of the destination either at the time when the notice was given or in the course of the appeal process. Nonetheless, the notice itself would not have been invalid, but that's because there was a subsequent procedure which would accommodate the relevant rights. Anyway.
Lord, Lord, on that analysis, the position would remain that the mandatory requirement in the legislation isn't met. The notice is defective. But the reason why the notice is not invalid is because of two things. The first, that the omission is immaterial, and second, there is no prejudice to the appellant's ability to present the appeal. Of course, it may be that the court is against me on the question of prejudice, but I do make submission that where an employer accepts before a judge that they have breached Section 15(1), they employed a worker with no leave to remain, then no matter how one looks at the situation, they are liable to the penalty. They fall squarely within Section 15.1.
There's a bit of a trap for the unwary, isn't it? The unrepresented employer might well accidentally admit that. A more substantial employer who's properly advised will be told absolutely don't say anything at the hearing that could be construed as you accepting that any of your employees had no right to work here.
Well, Milady, on that analysis, I mean, even if an employer says absolutely nothing, but there is sort of uncontested evidence from the Secretary of State, as was in this case.
That's not what you said. You said here the appellant ultimately accepted the evidence that the worker had no right here, and that was what meant that there was no prejudice.
Yeah, so in this case, it is indeed common ground that the appellant is liable to the imposition of penalty. He falls within Section 15.1.
But the scheme here is not we bring proceedings against you alleging that you're employing somebody illegally, and then there's a hearing at which all that gets decided. The situation here is we issue you with a notice, and it's at that stage that there's a finding against you, in effect. So either you've got the reasons at that point or you haven't.
And perhaps to put the same point in a slightly different way, and the notice is almost like the judgment of the Secretary of State, out of which the obligation to pay has arisen. And usually when you get a judgment which affects your rights and requires you to pay, you're entitled to know the full reasons, not part of the reasons.
I take the point. Of course, I'm not going to simply repeat the submissions that I have made. It really comes down
and we're putting you in a slightly awkward position because we're sort of putting points to you, and I think you're saying, well, they're covered by my previous submissions, which we understand.
Yes, but the proposition of law that I advance is that in deciding whether the notice is invalid, the court has to look at the two matters: whether the defect or omission is material, and whether it caused any prejudice to the appellant. If the court takes the view that, well, it is material, it caused the prejudice in the sense that the appellant is not entitled to the reduced amount, then that means that the point fails. Mm-hmm. But I do submit that this isn't a case where this is the point that, unless I've missed it, is made by the appellant. He's not saying that, well, I would have paid the reduced amount if you had made it clear at the outset that the worker had no leave.
Sorry, just on that, I think that's because the Soneggi point has only been raised in this court. I mean, who knows what he might have done if it had been raised at first instance and the employer appreciated that there was this argument based on the Soneggi middle ground, and everything might turn on whether they suffered prejudice or not.
And what I mean, my lord, is that, well, once the point is raised, you'll see that there's nothing in the appellant's case that addresses it.
Right. Okay.
And there isn't a submission, my lord, that where the appellant is saying that he would have that they would have paid.
It's not a matter of submission; it would be a matter of evidence, and he can't put in any evidence at this stage.
Yes, I mean, of course, one of the reasons for that is that the county court took the view that there was no non-compliance with the statute, and the Secretary of State had not sort of given a new reason.
That's right, but that's why I was putting to you before that the predicate for your Soneggi argument is that there has been non-compliance. So we can't approach it on the basis that the county court did, saying there has been compliance, yes, because the whole point of this argument is an acceptance against your primary submission, which we well understand, that there has been non-compliance. So we have to approach it, this argument, on that basis.
Yes. So that, my lord, would explain why there is no evidence of prejudice. But that, in my submission, does not undermine the submission of law that I'm putting before the court, that prejudice and materiality are relevant.
Well, I know you've said that many times now.
Yes.
In our written case, we referred to the more recent authorities where synergy was considered. I mean, I do not propose to take you to those authorities unless you wish me to. Perhaps just to flag that there is a recent judgment by the Court of Appeal in a case called Chowdhury. So when the Supreme Court granted permission to appeal in this case, permission to appeal was also granted in Chowdhury, which raised a synergy sort of point. But that appeal ultimately settled by way of a consent order. And if you wish to see the judgment of the Court of Appeal in that case, it is at page 393 of the authorities bundle. That is one of the examples where the synergy argument was rejected, and the Court of Appeal found in favor of an appellant, not in the context of civil penalty, but in the context of general immigration.
But I'm so sorry. When you say the synergy argument was rejected, is that to say the synergy middle ground interpretation was rejected, or on the basis of the synergy middle ground interpretation, on the facts, it was found that there hadn't been substantial compliance with the requirement?
On the facts. So that was a case about notices, regulations. The notices, regulations, among other things, say that an appellant must be advised of the right of appeal to the tribunal and the grounds on which a person may bring an appeal. The notice of decision in that case stated that there was no right of appeal and did not identify the grounds on which a person may pursue an appeal. So the advice that was set out in the notice of appeal was misleading. And the Court of Appeal took the view that the availability, if you wish to look at the judgment, it's at page 393.
Yes, and the relevant part of the judgment is, where can you help us?
Yes. Paragraphs 27 and 40.
27 and 40.
Yes. So 27, you'll see the submission that is made by the Secretary of State. And 40 is the rejection of the submission that there was no adverse consequence because the appeal was bound to fail.
Yes, thank you.
Unless I can assist you any further, these are my submissions. I've sort of tried my best to answer your questions, but these essentially are my submissions. I haven't gone through each and every ground of appeal. The question of statutory construction and the synergy question are the essential two questions in the appeal.
Yes. Thank you very much.
Very good. Thank you.
Mr. Mann.
Substantial to say a response.
All right.
You've had the points. I think you've got them very well. And I stand by the point that I made as well regarding the synergy point. Same point that you've taken with my learned friend. It doesn't really make any difference in this particular scenario. Unless I can assist any further, that would conclude matters.
No, thank you very much. Well, that is the end of the hearing. The Court's very grateful to counsel for their submissions and to those assisting in the preparation of the cases. We will now adjourn and we will consider our judgment and deliver it in due course. Thank you very much.